Hi everybody. Today's topic is regarding plea bargaining. So I have shared the screen with you. So let us talk about evolution and development of plea bargaining. So plea bargaining is one of the most important topics in CRPC, and we'll be covering this today. And when you read CRPC, chapter 21A of CRPC talks about plea bargaining. And first, let's start with evolution and development of plea bargaining. So whatever concept you read, we must know what is the evolution, what is the basis of that doctrine. So doctrine of plea bargaining, let us start with this doctrine of nolo contra. No, nolo contra means I do not wish to contend. It is again a Latin word. It means I neither accept or deny the charges, but agrees to accept the punishment. So plea bargaining is one of the latest concepts in criminal law. And you see a lot of questions are there from this field of criminal law in your examinations. So the modern concept of plea bargaining emerged in 19th century, having its trace in American judiciary. India did not feel the need for plea bargaining due to the presence of the jury system until 1960s, when legal representation was permitted. So first and foremost case which we'll be discussing will be of Madanlal Ramchandra versus state of Maharashtra. So it is a very important landmark case because in this uh, court held, if you can see para 1, we pointed out that the High Court adopted an unusual course in the case. In fact, a similar course was suggested to us at the hearing by submitting that we should increase the fine and reduce the sentence to the period indefinite. In other words, the accused were adopting the same method which they did in the High Court, namely that they will pay the amount which they have wrongly released from JR firm, and this may be taken in mitigation of punishment imposed. Second finding was, in our opinion, it is very wrong for a court to enter into a bargain of this character. Offences should be tried and punished according to the guilt of the accused. If the court thinks that leniency can be shown in the facts of the case, it may impose a lighter sentence. But the court should never be a party to a bargain by which money is recovered from the complainant through their agency. So, moving further, we had another case by the name of Muralidhar versus state of Maharashtra. So here, in this case, the court held that the prosecutor is relieved of long process of proof, legal technicalities, and long arguments, punctuated by revealing exertions to higher courts. The court sighs relief that its audience, surrounded by a crowd of papers and persons, is avoided by one case less, and the accused is happy that even if legislative battles might have held out some astrological hope of abstract acquittal in the expensive hierarchy of the justice system, is free early in the negotiated settlement of criminal cases. So, as obtains in the United States. So here the court discussed the concept of plea bargaining, which was already very much in existence in USA. So here it suggested for introducing this concept of plea bargaining. So eventually, when you see further, it was challenged in 1980. The Supreme Court held that practice of plea bargaining is unconstitutional, illegal, and would tend to encourage corruption, collusion, and pollute the pure form of justice. So, originally in 1980s, you see these judgments. Supreme Court was against the concept of plea bargaining because the Honorable Court's observation was it will increase the corruption, the collusion, and pollute the pure form of justice. Eventually, what happened? State of Uttar Pradesh Chandrika 2000 case, the apex court held that it is a settled law and on the basis of plea bargaining, courts cannot dispose of the criminal cases. The court has to decide it on merits. If the accused confesses its guilt, appropriate sentence is required to be. It was further held that neither a mere acceptance or admission of the guilt should be ground for reduction of sentence, nor can the accused bargain with the court that he is pleading guilty, sentence should be reduced. Highlighting the glaring inefficiency of Indian criminal system, the Law Commission of India in 142nd report impliedly underlined the need of plea. So there was a committee formed by Justice Malameth Committee. This committee is one of the very landmark committees which suggested improvements to India's criminal justice system. So Justice Malameth Committee is very, very important of 2003. Moving further, State of Gujarat versus Natwar Harchand. So here, the judgment was delivered when the CRPC Amendment Bill 2003 was introduced in Parliament and pending for consideration. Here, before the Gujarat High Court, the issue whether the trial court can impose punishment less than the minimum punishment prescribed under the statute came up for consideration. So here, what happened? The learned judges traced legal history. Eventually, they observed and said that very objective of law is to provide easy, cheap, and expeditious justice by resolution of disputes, including the trial of the criminal cases, and considering the present realistic profile of pendency and delay in disposal in the administration of law and justice, fundamental reforms are inevitable. There should not be anything static. So eventually, Chapter 21A of CRPC, that is Section 265A, Clause 1, the plea bargaining shall be available to the accused charge of any offense other than. So here they have specified the categories where plea bargaining will not be. For example, exception was created for imprisonment offenses punishable with death, or imprisonment for life, or imprisonment for a term exceeding 7 years, and such offenses which affects the socio-economic condition of the country, or has been committed against a woman or a child below the age of 14 years. So it was notified, and eventually Section 265A, Clause 1 was introduced in criminal procedure. So the central government, so in exercise of the powers conferred under subsection 2 of 265A, the central government had notified offences under 19 acts, offences affecting the socio-economic condition of the country. So what are those 19 offences? You can just have a look. Dowry Prohibition, Sati Prevention Act, Indecent Representation of Women. So all these 19 acts, this category of offences was made by the central government. So then moving further, let's understand the procedure. Section 265B contemplates an application for plea bargain to be filed by the accused, which shall contain a brief description of the case relating to which such application is filed, including the offence to which the case relates, and shall be accompanied by affidavit sworn by the accused, stating therein that he has voluntarily preferred, after understanding the nature and extent of the punishment provided under the law of offence, the plea bargaining in this case, and that he has not previously been convicted by a court in a case in which he had been charged with the same offence. Similarly, you see Section 265C, it prescribes the procedure to be followed by the court in working out a mutually satisfactory disposition. So, as you all know, there are two kinds of cases instituted in criminal law. One is under complaint and one is under plea. So, in a case constituted on a plea support, the court shall issue notice to the public prosecutor concerned, investigation officer of the case, the victim of the case, and the accused to participate in the meeting to work out a satisfactory decision. In the complaint case, the court shall issue notice to the accused and the victim of the case. Now moving further, section 265D deals with the preparation of the report by the court as to the arrival of a mutually satisfactory disposition of failure of the same. The parties arrive at a mutually satisfactory disposition. The court presiding officer is prepared and forward for further proceedings. Now, moving further, section 265E prescribes a procedure to be followed in disposing of the cases when a satisfactory disposition of the case is arrived. So all this you will read from your Bail Act. It is all given in the Bail Act. So you can just go through all these provisions. Let's sum. Voluntariness, informed choice, and mutually are the main features of the process of plea bargaining. Plea bargaining is a voluntary process in which the parties exercise their informed choice after mutual discussion. An accused intends to plea bargain for a reduced sentence or compensate the victim of the offense. The court has been enjoined upon to ensure that voluntary character of the process of plea bargaining under subsection 4 of section 265B of the CR. So, the court is under a legal duty to examine the accused in camera to satisfy itself that the application was filed by the accused. Court must inform the accused implications of the plea of guilt and possible sentences in the case. The accused must be put to notice that in case his plea bargaining is separate, he will be convicted for the offences and sentenced accordingly. So let's talk about the types of plea bargaining. One is charge bargaining. Normally, it is a synonym for plea bargaining. It involves negotiations of specific charges of crimes that the defendant will face at trial. Usually, in return for plea of guilty to a lesser charge, the prosecutor will dismiss the higher order charge. For example, the defendant charged with burglary may be offered the opportunity to plead guilty to attempt burglary. It is therefore basically an exchange of concessions by both sides. Then we have sentence bargaining. It involves the agreement to a plea of guilty for the stated charge rather than a reduced charge in return for a lighter sentence. So, further we move on counts bargaining, facts bargaining. So let's talk about the advantages of it. First, it's time saving. It will help in cutting short the delay and backlog of cases. Compensation of victims must be benefited as they could get money compensation. Benefits of accused. So all these are the advantages of plea bargaining. Disadvantages: allow unfair means to escape, is an alternative way of registration of crime to some extent and hence not a fair deal. So these are basically. So let us talk about conviction of innocence. This process might result in a phenomenal increase in number of innocent convictions. Innocent accused may be paid by the actual perpetrators of crime in return for their guilt plea with a sure reduction. So implementation. Let's talk about implementation. So this is the latest case of 2022. It's a policy strategy for suggestions for effectuating the provisions regarding to. So here, as a pilot case, one for each of 11 judicial magistrate first class or court of session in each case. The said courts may identify cases pending at the trial stage and evidence stage, and where the accused is charged with offences with a maximum of 7 years in learned code will exclude cases mentioned in section 256 years, namely offences of less than 14 years. Then next, it says the identified cases can thereafter be posted on a working Saturday or any other day which is suitable to the court with the notice to public prosecutor. Complainant and the accused, the said notice would indicate that the court refuses to consider disposing of the cases under Chapter 21 of CRPC. Provision of Vendors Act or compounding letter section 3. So the notice would also indicate that the accused complainant would be entitled to avail legal aid in the case. Legal services will be made available to the same. It also be made clear that accused has to be present whenever they are located and the condemned may be and the condemned may be present with the same. So the public prosecutor would be required to ascertain the criminal antecedents of the accused. Only cases of first-time offenders will be taken. So this is again one of the parameters. On the date fixed, the court can inform the accused with provisions of pre-bargain. The court can also pursue the parties who compound the offence if the offence is obviously compounded. The court can also inform the accused of the benefits of probation of Offenders Act. Service of panel lawyers and district legal services authority will also be available to the accused. Court may give time to the accused to think over the matter and give. In cases where the trial is in judicial custody, the trial court may explain to the accused and then counsel appearing for the accused to explore the possibility of pre-bargain or compounding of or benefit of probation of Offenders Act. The accused can be given time to consider the matter. Services of panel lawyer or district legal service can also be made available. That's all for today. Thank you. God bless you.